Mr. Aaron Schlenker was ordered to surrender all firearms after making multiple threats to medical staff and law enforcement. This enraged him. On February 14th, he made over 20 calls to 911, and during the last call, he stated, "I'm going to F some people up. Thank you. I'm done. I'm effing done." Following this call, he walked down Long Beach's Pacific Avenue with a baseball bat and smashed multiple businesses, including police department headquarters. He was arrested, and while riding in the back of a patrol car, he threatened to strangle the officer and kill his children. Mr. Schlenker now argues that 10 critical errors were made during his prosecution, and he seeks a reversal. He argues his constitutional right was violated when he was unable to privately confer with counsel during a remote hearing. He claims an error was made when refusing him a voluntary intoxication instruction. He also argues ineffective counsel. Let's get it started.
State of Washington versus Schlenker. Is that how I pronounce that name? Is that correct?
Yes, Your Honor. Yes, Your Honor.
Okay. Mr. March, if you'd like to reserve any time for rebuttal, please let us know, but understand the clock's going to continue to tick down. Can you see the clock?
I can, Your Honor. Thank you. And if I could please request 4 minutes for rebuttal.
All right. We will try and warn you when you start dipping into that time, but again, watch that clock, okay?
I will.
Thank you, sir.
Mr. March, this is Judge Fearing. I'm wondering, did Mr. Schlenker in his first brief that he filed argued?
I think we're starting, the clock should probably be going.
Argued that his Sixth Amendment right was violated because he did not have access to counsel during the WebEx hearings?
No, in the original brief that was filed in Division 2, that was not included in the argument.
Did Mr. Schlenker get permission to file a supplemental brief?
No, but there was a matter that was consolidated with this matter with regard to the restitution hearing. And I believe it's been a while, Your Honor, but I believe we requested the ability to file a additional brief, like to substitute.
Was the case still in Division 2?
No, I don't believe so. I don't believe so.
Did the commissioner give permission to file the supplemental brief?
Well, it's not really a supplemental brief. I believe what happened was and I do think there was leave to present a new brief altogether, like to withdraw the original brief and enter a substitute brief. I do believe so, but again, I'm not really prepared to answer that question without going back through the procedural history of this appeal.
Okay, I started asking you questions without giving you any opportunity to talk, so I'll be quiet now.
Well, no, and I would normally introduce myself by saying, may it please the court, Kevin March on behalf of Shaun Schlenker. So if Your Honor has concerns about the ability of Mr. Schlenker to raise the Sixth Amendment claim, which it sounds like Your Honor does, I don't know how we would proceed with that. I can go back through and perhaps prepare a letter to the panel detailing what occurred, if that would be helpful.
We will let you know if
Okay.
We'll send you a letter in the event that we want you to address that. Thank you.
Okay, thank you, Judge Fearing. I was actually going to start today not with that claim, but with the denial of the voluntary intoxication instruction, which deprived Mr. Schlenker of his ability to present his chosen defense. As the state concedes in its briefing, the two, well, I guess I'll back up. The three things that the accused needs to show to obtain a voluntary intoxication instruction is that 1, the crime includes a mental state, 2, there was substantial evidence of drinking, and 3, that evidence of drinking affected the ability to form the requisite mental state for the crimes. The state concedes in its briefing that the first two elements are met. They're not in dispute here. The only element that is in dispute for that is whether the drinking affected the ability to form the requisite mental state. And there was significant evidence presented in the trial from police officers, from Mr. Schlenker himself, that the alcohol he was intoxicated, and it didn't affect his ability to form the requisite mental state. Officers said that they couldn't understand Mr. Schlenker because he was speaking belligerently, and also indicated that Mr. Schlenker appeared not to be able to understand them with simple commands such as getting on the ground. Mr. Schlenker made threats to one officer who was transporting him to the hospital for a pre-jail clear check. And he made those threats, and that officer explicitly said that he thought, because Mr. Schlenker was under the influence of alcohol, that his intoxication played a role in making those threats. And then another officer testified about a previous extreme risk protection order that was in part based on Mr. Schlenker's alcohol consumption, and claimed that his behavior on this night, February 14th, 2021, was, quote, very similar to how he appeared back with the extreme risk protection order. And then, of course, Mr. Schlenker also testified that his alcohol consumption had something to do with his behavior that night. So we contend that the trial court erred in denying the voluntary intoxication instruction on the ground that there was not sufficient evidence or substantial evidence of intoxication. There plainly was substantial evidence of intoxication. Yes.
So I have a question for you. Assuming that it was error, as you claim, what is the level of review for prejudice?
So that is kind of a confusing question, but I would point the court to there's really, prejudice is established when the defense is not able to mount their chosen defense. And I would point to a recent Supreme Court decision, State v. Arbogast, which is 199 Washington 2nd 356. In that case,
okay,
the defense,
Mr. March, do you address this level of prejudice? I mean, is it constitutional harmless error? Is it abuse of discretion? Is it identify the level of prejudice?
It's not constitutional harmless error. The level of prejudice is that if the defense is not able to present their chosen theory, their chosen defense to the jury, it's almost a per se prejudice at that point. And we would rely again on Arbogast for that proposition. And
okay. So
we would
Mr. March,
yes.
So then if the question is whether you were prevented or Mr. Schlenker was prevented from arguing his theory of the case, am I correct that the closing arguments in this case were not provided as part of the record?
No, the closing arguments were provided as part of the record.
Okay.
I believe.
I looked through, I'll have to look through again and see if the closing arguments are in there, but was counsel prevented from arguing that intoxication impacted his ability to form the requisite intent?
I don't believe that counsel made that argument in closing, because counsel did notify everyone that that was his intended defense at the beginning of the trial. And but I don't believe counsel was able to, and even if counsel did argue that intoxication prevented Mr. Schlenker from forming the requisite intent, the jury received no instruction on the law saying that they could rely on that level of intoxication for his inability to form that requisite intent. And that really goes to the prejudice question. Really, what we have here is a trial where there was substantial evidence of Mr. Schlenker's alcohol use, and intoxication. Yet we have no corresponding benefit to Mr. Schlenker for putting in all of that evidence about that. That was his chosen defense here, and basically the jury would have been left with a lot of evidence that he was intoxicated, but they had no instruction on what to do with that evidence or how that would have factored into their decision making. And that under Arbogast, and we would also cite State v. Korestein, which is a 2013 Washington Supreme Court case, 177 Washington 2nd. In that case, the court held that prejudice is established when the defendant does not get to control and mount the defense of his choosing. In that case, instruction was given over the defense objection, so it's a little bit of a different scenario. But still, the Supreme Court said that the prejudice was inherent in not being able to control and mount the defense of one's choosing.
Mr. March, hang on here just a second. There's just a difference for me between not instructing the jury on voluntary intoxication and prohibiting a defense counsel from arguing that intoxication had an impact on a person's ability to form an intent. Is there any evidence in the record that the attorney tried to pursue this defense and was denied the ability to pursue the defense?
Well, yes, by virtue of the defense attorney saying at the outset of trial that this was his defense and getting approval from the court to mount that defense at the outset of trial, and then being denied the instruction that would have supported that defense before going into closing.
But there's nothing in closing where he starts to go into this defense and an objection is made and the judge sustains the objection and says you can't go down that road.
No, not to my knowledge. But again, Your Honor, I don't see how a defense attorney in that position who's denied the instruction on the law would be able to argue. I mean, we would just be left with counsel's argument without any legal support in the jury instruction. So counsel was hindered in his ability to mount that defense on behalf of Mr. Schlenker. And that is what is prejudicial in these circumstances. And Kruger, which we go
March,
ahead.
You're into your rebuttal. I'm not sure if you want to continue.
Sure. I'll actually reserve the balance of my time. Thank you.
Thank you. Mr. Newman, you're on mute.
Yes. Actually, I would like to talk first about the Sixth Amendment issue, because I don't think that there's a valid argument here, mainly because the appellant represented himself for
Mr. Newman, does the state object to this court entertaining the argument?
You know, I actually thought that their permission was given. What I remember happening is that a second appeal was filed and they were consolidated. And because of the court consolidating them, I thought permission was given. But if I would have objected to the consolidation if I was given notice. And if I still object to it. I don't know if filing a second appeal is something that can be done. I got notice that there was a consolidation, and I did not object to that point because I thought permission had been given.
Mr. Newman, it's the state's position that Mr. Schlenker represented himself. Did the trial court ever perform a colloquy with Mr. Schlenker about representing himself and give Mr. Schlenker permission to represent himself?
Yes, Your Honor. I have that here. Okay, there was some talk this is in the record on page 19. Reported proceedings, page 19. There was a discussion between the defendant and the court, and it finally came down to, well, it's either he's representing you or he's not. Are you asking him to just be standby counsel so they can represent yourself and then ask questions, I think that's it. Yeah, I think that's what
Mr.
I'm
Nathan,
going for, Your Honor.
Which page is this on, sir?
In my brief, it's on 8, but in the report of the proceedings, it is on page 19.
19?
Of which date?
This would have been volume 1, report of proceedings, volume 1. This is date.
Okay,
October 1, 2000.
Did the trial court then engage in a colloquy with Mr. Schlenker and give him approval to represent himself?
Yes, yes, he did. I can pull that up.
No, that's all right. Well, I don't want you to spend that time. Did
I believe
did any critical hearing occur before this hearing where the court gave permission?
There were critical stages, but I think the only critical stages were arraignment, which generally nothing happens at arraignment that's going to affect the outcome of the trial. There was a waiver of speedy trial, but there is no way that could affect the outcome of the trial. But after that,
does the Bragg decision indicate that those are critical stages such that there should be reversal by reason of?
No, the Bragg decision did find those were critical stages, but did not find that those individual hearings amounted to prejudice. They ultimately found that the first stage, critical stage, that warranted reversal was when the appellate's attorney rejected the state's offer of resolution. That was the first stage at which they believed that prejudice happened, because they believed that if he was in the courtroom, understood the magnitude of the decision that was being made, he might have consulted his attorney at that moment and not rejected the offer. And I guess there's the assumption that once you reject the offer, you cannot accept it after that. And that might be true in this case. In that case, I don't know. But that was the first critical stage that they did any analysis on. They did not talk about the arraignment. They didn't talk about any of the speedy trial waivers. But it was at that point he gave up something that could have affected the ultimate outcome of his case, being how much time that he would have been sentenced to. And then here, there was some talk about a plea offer in one of his hearings, but there wasn't a rejection. Really, all of the things that happened prior to him representing himself were basically him complaining about his attorney and the attorney being removed and them putting off the trial because of that. The speedy trial waiver was
during the hearing that trial counsel was removed and the court gave Mr. Schlenker permission to represent himself. Did Mr. Schlenker have an opportunity to converse privately with his attorney before insisting on representing himself?
Well, I do not believe so, but if he intends to fire his attorney, I don't know how consulting with his attorney at that point is going to change his decision. I mean, if he's making the decision
because
to fire,
the attorney could aggressively and wisely counsel Mr. Schlenker that he's a fool for representing himself.
well, I believe that if a defendant is going to fire his attorney, that the relationship has been broken down, that he's grown so frustrated with his previous relationship that he just has no intent to go forward. I don't know if it is really something that a defense attorney should do is to try to, convince his client to not fire him. Once the client has made that decision, I think that a defense attorney probably is duty bound to just bow out. But that is my position on that issue, that everything important that happened that would have affected the outcome of the trial happened after he represented himself. And now as to the voluntary intoxication, now this is an issue that the court specifically ruled on and said that there was no evidence of intoxication. And I think what the court meant is that nobody said he was intoxicated. Yes, he acted in a way that he did, but there was no testimony that he actually was intoxicated. The defendant certainly has had mental health issues. If you read the pretrial record, he did go through a 1077 evaluation, and that certainly could have affected his behavior on that night. But there's no evidence that intoxication, that he was intoxicated. And that's ultimately, the court reviews this decision for abuse of discretion. And that's the City of Seattle versus Person, which is included in my brief. And also, with 18.10, it is a statement of the law, but it's also a statement of common sense. This is something that could be argued without the jury instruction. That you,
Mr. Lumen, let me read to you, Mr. Lumen, let me read to you some of the testimony of Casey Mailing, M-E-L-I-N-G, who I believe was the deputy chief of police for Long Beach, beginning at page 240. And Mr. Mailing was present when Mr. Schlenker was being arrested. Question, and so did it appear he, Mr. Schlenker, was exhibiting mental health in that September time? A, mental health and alcohol. Question, when you say alcohol, you mean alcohol intoxication? Answer from Deputy Mailing, correct. Why isn't that sufficient to get a voluntary instruction on voluntary intoxication jury instruction?
I think it is something that could warrant the instruction, but apparently the court did not believe that it was sufficient evidence to warrant the instruction. And ultimately,
the trial court didn't believe the trial court didn't believe the testimony of the deputy chief of police.
No, I think the court said that there was no evidence of intoxication. I don't know if that's because he didn't believe the deputy chief of police, or that he just didn't believe that it was sufficient to meet the standard for getting a jury instruction. But
what would meet the standard? What evidence would be needed to meet the standard?
I actually know of no case that talks about what is the standard for getting an instruction for like intoxication, or I think basically it comes down to the court's discretion of what would be helpful to the jury. And I don't know if this instruction would be particularly helpful to the jury. And maybe that was his decision.
Mr. Newman, let me ask you a question on the sufficiency of evidence for the malicious mischief charge. Was there any evidence of damage to anchor realty?
I don't believe that there was testimony regarding that.
Okay. And the jury instructions indicated that they needed to find there was damage to the 3 businesses, correct?
Yes, and it was argued in closing argument that they had to find damage to all of the businesses. Actually, I thought there was evidence of damage to realty.
You didn't point out evidence.
What?
I'm sorry, you did not indicate any evidence of damage in your brief.
Oh. Well, I guess I'll have to defer to the record on that. I certainly conceded that the restitution to Anchor Realty was not warranted. So, yeah, I can only defer to the record on whether or not there was sufficient evidence to prove damage to Anchor Realty for the purposes of the jury instruction.
Thank you.
If there are no other questions, then I'll just defer to my brief.
Thank you. Mr. March, I believe you have about 3 minutes and 49 seconds.
Thank you, Your Honor. So I just wanted to address Judge Fearing's initial concerns. I went back while the state was speaking. While this case was still pending in Division 2, I moved to consolidate. As one of the requests in that brief, I asked to supplement both the record and the briefing. And although the ruling that was entered on February 15th by this court doesn't address that specifically, it says motion to consolidate is granted. That was one of the grounds for relief stated. I'd also like to get into the standard of review here for the voluntary intoxication instruction. The state says it's an abuse of discretion standard. That is not accurate. What the court is supposed to do is view all of the evidence in the light most favorable to Mr. Schlenker. With that view, there was, as Judge Fearing pointed out during the state's remarks, evidence the officers thought that Mr. Schlenker was intoxicated. Also, I believe it was Officer Natsiopoulos at page 204 of the RP was explicitly asked whether his intoxication impacted his threats, and he answered yes. So there was ample evidence of intoxication, and we contend that the denial of that instruction made it impossible for the jury to consider or to inform the jury how to consider the intoxication in this trial. I'd also, I don't have very much time to address it at this point, but in terms of the Bragg issue and the Sixth Amendment issue, I will point out that Mr. Schlenker never did represent himself in this trial. There was a conversation about him making defense counsel stand by counsel at the October 1st review hearing. And he says, maybe I would have him as standby counsel. However, that never came to fruition. The counsel continued on the case. And I will point out also that at other hearings, there was contentious relationship evident from the record between Mr. Schlenker and his various attorneys that he went through, and his inability to confer with them privately at any point at any of the pretrial proceedings. The court has to analyze whether there were no ground rules laid as in Bragg. They required Mr. Schlenker to interrupt the proceedings if he wanted to get counsel's attention. And also, Mr. Schlenker repeatedly objected at the outset to having to appear via Zoom separated from his counsel. So, I mean,
Mr. March, I read the record entirely, and I found one instance where he objected to not being able to have private access to his counsel. And that, I believe, was in March. When you say he repeatedly did this, I guess
I would point the court to page 580 of the RP, where he again objects to the way this hearing is being conducted. I agree with Your Honor that he didn't say
that he doesn't say at that point in time that it's because he can't contact his attorney, correct? I mean, he raised a lot of objections, but they weren't pointed to his inability to contact his attorney.
No, the subsequent objections were just basically on the Zoom platform or the WebEx platform that was used. Yes.
Right.
So I see that I've run out of time. If the court has any further questions, I'm happy to answer them. Otherwise, I would ask that the Court of Appeals reverse Mr. Schlenker's convictions and remand for a new trial.
If we reverse the conviction based on the Sixth Amendment, do we still have to address whether there was sufficient evidence to convict on malicious mischief in the second degree in count 2?
Yes, Your Honor, because the remedy is different for sufficient evidence. So that would prohibit the prosecution under the double jeopardy clause from proceeding against Mr. Schlenker again for that same.
Thank you.
All right, thank you. This matter will be presented.
Following these arguments, the court reversed all convictions. They remanded for a new trial for all charges except count 2, malicious mischief. The Superior Court was directed to dismiss count 2. Well, Mr. Schlenker got lucky today. Let me know what you think about this court decision in the comments below.